All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140657, Kimball et al. Versus Perkins et al. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and your client. Each side will have 20 minutes for argument. I understand there is a cross appeal, and in theory, if the cross appellants have time left over, you get the last word on your cross appeal, but you can use your 20 minutes however you see fit. And we have read the briefs. We've conferenced the case prior to argument, and we believe we understand the procedural history. So with those preliminaries out of the way, counsel for the appellant, you may proceed.
Thank you, Your Honor. David Cole, and I represent the LLC appellants in this proceeding. I'll be the sole person arguing for the appellant side. It's a big record, long trial, no doubt about that. But in reviewing the record to try to find some things to key on for the presentation, there's one thing that is really not in dispute, and that is that the events that put in motion the yet more events that gave rise to this litigation all happened a long time ago, more than 5 years ago. The death of Mr. Perkins was a long time ago. The conveyance out of the estate was in the early 90s, as was the subsequent trustees' sale. And in looking at those facts and what we believe is the relevant and controlling statute of limitations, I was just struck by how the facts of those conveyances and the statute come together. The statute, of course, is 141106, and it's our contention that as to parties in the position of my clients, the LLC, defendants 7-Bar and Banjo, it is a statute of repose. There is a regular sort of limitations period in that statute for other parties involved in transactions relating to probate proceedings that are challenged as having gone astray. But someone who did not perpetrate the fraud, which is us, there's a 5-year hard stop. End. No more discovery rule, no nothing. And we are not only in that position because these events took place more than 5 years ago, but we didn't exist at the time. Not only had these events taken place and the parties moved on and more history, water under the bridge, whatever you want to call it, we weren't even on the scene and didn't even exist. So I think if there's ever a situation where this statute has particular bite, it would be in that factual situation. There are a couple of legal points made in the brief. There is a question in the briefing as to how broadly the word fraud should be read in 141106, because it does speak to having some sort of fraud take place as a prerequisite for going there. And there's a question as to whether that extends to breaches of fiduciary duty and back and forth. I think the case law on that is well briefed. The thought I had in reviewing the brief in that case law as to how one applies that word fraud would be it would extend to an intentional, knowing breach of duty by someone in a position of authority with respect to an estate. It would exclude negligence claims or, oops, something didn't get handled the right way, that sort of thing. But in this case, there's just no getting around what the gravamen of the complaint is. I think it's precisely what this statute is intended to address. The point is also made in the briefing that perhaps it's intended only as a sort of Rule 11 federal court type thing. It extends only to false statements made in probate proceedings, and it certainly includes that. That language is in the statute, but then there's an or and a much broader statement after that. So I think the drafters of the statute certainly targeted one evil at the beginning of it, but they went on to target others as they went forward from there.
But doesn't constructive fraud have an additional element that isn't necessarily essential to the claim for constructive trust, for a constructive trust based on breach of the fiduciary duty, specifically the justifiable detrimental reliance? I mean, I'm not sure that they're synonymous the way you're trying to say they are for purposes of the statute of limitations.
Well, there certainly are there's different species of fraud. There's no question about it. And we have a statute that doesn't name a species. It just says fraud, although it's talking about a probate situation. And I've tried to separate in my head to read it the way the appellees would like to read it, you have to graft words in to say fraud by omission, specific kind of fraud. Now, perhaps I'm guilty of the same thing, but you've got to do something. You've got to pick some kind of a fraud. And I think in the context of a probate proceeding, where you have people that are charged with duties of disclosure and telling the world what they're doing, the judgment should go my way on that. I think to read constructive out and impose the language they want to creates a sort of a weird get out of jail free. If I don't say anything overtly misleading, well, that's okay. But if I kind of sneak around and hide things, that's different. I don't understand why that would be a meaningful distinction. So yes, there are some different elements depending on the cases that you look at. But in this context, in terms of what people actually would be doing and the need to apply the statute one way or the other, I think you have to sort of look at the goals of the statute.
What if the Superior Court here seemed to be of the view that the other heirs were led to believe that Ms. Kimball was holding the property for their benefit? Why would we impose the fraud statute? At what point did they necessarily know that there's a fraud?
Right. Well, so as under the statute, of course, as to my clients, there's a hard stop. The knowledge issue doesn't come into play. As to the issue of some sort of contract claim, independent of what may have happened with the probate proceedings, I question whether that's valid. I mean, you have to have had the probate prerequisites to that claim, but we've briefed that on some other grounds about statute of frauds and issues of that nature. I don't think you can get around it by saying, well, there were some later promises made. There's some legal problems with that, but I think it originates out of the same problem with the probate proceeding, and then triggers the 5-year period. The other related facts about that, Your Honor, of course, that's all oral communications that give rise to those claims. But the written documents around that time, which is what we know about when we come on the scene some 15 years later, are this deed that conveys it out of the estate. It is done with all PRs signing off on it. It is done with approval of all the relevant heirs. It proceeds to a bankruptcy. There is a motions presented to have stay relief granted. There's a concession made by the primary obligor in the course of those proceedings so it can proceed. And then there is a trustee's sale with a statute that explains exactly what the effect of that is. And I emphasize those points to go to the sort of the merits of the claim you speak to, Judge. That it's not looking back at these facts, any time there's a situation like this where someone's threatening foreclosure and you're going to lose property, we got to do something, right? And they did something. But what they did was had a very specific set of rules that governed it and had very clear statements left in the record about what they did. They took a piece of property and they deeded it with no reservation, no sign to anyone, no warning that we're just kidding, we might take it back someday. They go to court. They argue to the court about it. Things happen, and then a very specific procedure happens with a very specific consequence under 33811E. And the analogy I was using, I think it's in the briefing, but in just thinking about it, is you go to the casino and you put it all on red 7. And you hit red 7, you make a lot of money. You don't hit red 7, you don't get a do-over because you had some intent in your mind, or you had some wishful thinking, or you had some hope. I don't question for a second that people had a lot of hopes and dreams about what might happen if they were able to make it work. And they came close back in the early 90s. I concede that freely. They made the conveyance. It was treated as a valid conveyance, and it bought time, and a lot of time, to try to work something out, over a year. And in fact, it produced some benefit. But at the end of the day, it didn't, and it went through a very specific procedure that ended those matters. And then many, many years later, we come on the scene, and those are the records that we see. We see a deed, we see a conveyance, we see a bankruptcy court order, and we see a statute that gives effect to that.
Would you have had any problem if the Superior Court had simply imposed the constructive trust over the percentage of the property that Patty Kimball owned?
Well, you have to have a basis for it. I mean, there has to have been something to give rise to it. And what that something is...
I think you're saying it's breach of fiduciary duty.
Right, yeah, and that's the Right, because that's the only claim it could be. The only way you get to the fiduciary duty is through the probate estate, through the alleged defalcation as a personal representative of the estate. So any sort of constructive trust must flow from some finding of a duty that can only originate in a certain place, which I think triggers the same limitations issues. There's also correspondingly the issue of bona fide purchaser, which is in another, I'm sort of the limitations issue is at the front, the bona fide purchaser is more at the back when we come on the scene, but that would, I believe, also be a problem to that claim and to that remedy. The briefing here is, there's a lot of briefing, but the way I came at the issue of value and
Counsel,
sure.
I just want to get back on
Of course, yeah.
on your answer to Judge Catani's question. The statute, you were talking about the statute of limitations for fraud, and it's that you're arguing there's a statute of repose. No proceeding may be brought against one not a perpetrator of the fraud later than 5 years after the time of the commission of the fraud. But he was then saying, well, what about a constructive trust as to Patty Kimball? And that statute wouldn't bar that. If it was fraud,
Right. Well,
it wouldn't bar, that statute wouldn't apply to her because she was allegedly the perpetrator of the fraud.
that's true. That Ms. Kimball does not have access to that claim. The statute of repose part applies to the LLC defendants and to the extension of any remedy to them. But that is a distinction.
So if there was a breach of fiduciary duty, and if you want to say that's sort of fraud, if we were going to say that, then you wouldn't have any complaint about whether a constructive trust was barred by the statute of limitations as to Patty Kimball.
It's not really pertinent to the LLC defendants because we are the perpetrator and we come on the scene.
Understand.
So it would in a way they obviously affect each other, but it's not really, it's a distinction between the different appellants on that position. No question about that.
It seems significant to me, though, in terms of if the LLC may or may not have a claim against Patty Kimball. If the LLC thought it was getting 50% of the entire property, my understanding of what the Superior Court did here did not address whether the LLC may have some type of claim against Patty Kimball.
That's not part of what is on the record before us.
Is there something that would prevent the LLC from pursuing a claim against her?
Well, by this point, I haven't looked at potential limitations issues or anything of that nature. I haven't analyzed the claim. This has been a dispute about the ownership of the property, and our view is that we had good title to it. And what rights there may be back and forth between them, I can't say that I've looked at what those potential claims might be. If the court's I'm happy to give it a little further thought and send something in after the argument, but I haven't. It hasn't been part of the proceedings to this point. The one thing that struck me on the bona fide purchaser issue is, it gets briefed here and it gets briefed there, is what exactly got given. And the way I ended up summarizing it and thinking about it, was looking at that chart we had in our reply brief, is 7-Bar, which was created as the holder for the property and a couple of the other things that were done around that time, it basically gave itself. It was created and it got put into it property and money, and then it gave out ownership to the Kimballs and to the Tuckers. And that seems, it's a little slick maybe, but it's a pretty fair summary of what happened. You have a new entity that comes on to solve this problem, and the Kimballs get back a percentage of the new company, as do the Tuckers, and the new company goes forward with the property unencumbered by the legal problems that it had had. And yeah, it didn't all happen at the same time, and yeah, there wasn't just one check that did everything, but that's an exchange of value. And the law on that says that it doesn't have to have a particular form. It's certainly a lot of money, and it's certainly the parties believe that they had created something new and valuable and went forward on that basis.
That's a good argument as to the Tuckers, but as to the Kimballs, who assuming we take the Superior Court's findings, that they took their interest on behalf of the other heirs. So
right.
there's not it doesn't seem to be any the fact that they now hold it, they're holding it on behalf of the heirs. I understand the Tuckers'
Right.
view, but they're holding one half.
And that's where it sort of gets a little confusing to me about who's holding what. I understand that point from the reasoning below, but 7 Bar, of course, is the entity that's holding it. It's the new entity. And 7 Bar, which is managed by Mr. Tucker, it is a new person new entity on the scene, newly created, management unrelated to the Kimballs, and it gives itself to both sides. Now, there may be some issue there on the Kimballs' side, but the entity itself gives value, and the entity itself does not have knowledge because it is managed by a stranger, Mr. Tucker, who no one suggests he knew a thing about this. It's not in dispute. And there are these arguments about agency that you see in the briefing, but you look at the law about that, and that's agency for what Ms. Kimball was doing with 7 Bar. She wrote some checks. Well, 7 Bar couldn't get out of that by saying you're not authorized.
Before 7 Bar was created, didn't the Kimballs and Tucker act as a joint venture? Didn't the court find they acted as a joint venture?
On the eve of the foreclosure, they write something down on the back of an envelope and say, let's do a joint venture to form 7 Bar.
The court finds it as a joint venture. Wouldn't that impute knowledge?
It could, I suppose, but in this setting, we're from the outset, they're trying to create a new entity, and that new entity is what takes the title. I just don't think that works. The LLC is separate from its constituent parts. The LLC is run in a certain way, and the rules about what it knows and does not know.
There were 2 parts of the LLC, and one, the Kimballs know, and if they knew and it's imputed to Tucker while there was a joint venture, doesn't that affect? You're saying that we erase all of that as soon as we get an LLC in place?
I'm saying we have to look at the purpose of the transaction. The only thing they wanted to do was create the LLC. If they'd been able to do it that afternoon, they would have done it, and there wouldn't be this question. The fact that Mr. Tucker came late and was doing it on the courthouse steps. In the real world, he didn't have any more knowledge than if he'd created an LLC then, and that's how we have to look at it.
But I go back to the point, though, assuming, is it possible then for someone to breach a fiduciary duty, if it's an unquestioned breach of fiduciary duty, do you get to keep the property simply by creating an entity that you're just a part of, where there are some people who are unaware of the breach of fiduciary duty, but that somehow insulates you from anyone going after the interest that you've obtained through a breach of fiduciary duty?
Well, there's a new entity here managed by someone who knows nothing, and in fact never knew anything. And there is equity on that side, I acknowledge that, but there's equity on my person's side as well. And to impute him with knowledge that he never had when he created a new business entity precisely for that purpose is not fair, and it's contrary to the reason why people routinely create that kind of entity.
You would agree that if there is a clear breach of fiduciary duty, it would not be fair to allow the Kimballs to keep their, let's say they got 90% of it, and the other individuals only had 10%. For them to keep 90, well, and whatever the percentage is, for them to keep it.
There would be some issues to be worked out there for sure.
But isn't that kind of what happened here? Whether we called it a constructive trust against her share, as long as the court's not saying, and the Tuckers or anyone else is not forever precluded from going after more of the share that they should have received. Why isn't that an equitable result?
In this particular context, the question is 7 Bar a bona fide purchaser for value? It gave a ton of value, and the person managing it didn't know anything about this and shelled out a lot of money because he didn't know anything about it. And I think those are the equities that weigh in favor of bringing this to an end after all those years. Call it latches, call it the LLC, call it limitations. There's equity there, but there's a countervailing equity that I think is the controlling one. Your Honor, if you have a question, I'll speak to it, or otherwise I'll sit myself down.
Say, when you're balancing equities, we give a lot of discretion to the trial court on how the equity should be balanced. We have to show an abuse of discretion.
Don't dispute it. I've tried to speak to pretty straightforward issues of law. If the court sees otherwise, then there is some deference to be given. I have no question.
Thank you. And Mr. Dangerfield.
Thank you. Good morning. My name is Mark Dangerfield. I'm appearing on behalf of Silky Perkins as the current personal representative of the estate, as well as Mamie Perkins, one of the 12 heirs of the estate. In one sense, this is a complex case because there's a lot of facts and legal issues floating around. There was a 9-day trial. There was more than 260 exhibits admitted at that trial. But at the heart, it's a pretty straightforward case of a breach of fiduciary duty by a personal representative, Patty Kimball. She not only breached her fiduciary duty as a personal representative, but as the president of East Chino Development, company owned by the same 12 heirs that are the heirs of the estate. And she found a way to orchestrate the removal of the property from the estate and to get it in her name, and told the other heirs, as the court found, that she was holding it only on their behalf. And the court found she did not repudiate that statement until March of 2008. Within a few months of that date, this lawsuit was brought. That's the heart of this case. I want to start with the statute of limitations, since that's where opposing counsel started, the 5-year statute of limitations that he cited as arguably barring this action.
Barring the action as to the LLCs.
Correct, Your Honor, barring the action as to the LLCs.
And, you know, by what you just said, it makes it almost sound to me like it's transformed from you could have a straight breach of fiduciary duty without any kind of misrepresentations or fraud going on.
Correct.
I mean, but you started to tread on, I thought, in sort of moving into a fraud aspect because of that Ms. Kimball told her relatives, yeah, I'm holding this for you, and she wasn't. And so doesn't that move it from a straight breach of constructive trust for a breach of fiduciary duty into a fraud issue, so the statute of limitations or the statute of repose might apply as to the LLCs?
No, I don't think it does, Your Honor, for a couple of reasons. First of all, fraud, we didn't bring a fraud claim to trial in this case. And it's not uncommon to have a fraud claim, to have a tort claim, in this case, a breach of fiduciary duty claim, to have several claims. And maybe some of those claims would be barred by the statute of limitations and others wouldn't. But a fraud claim does not bar a breach of fiduciary duty claim. I mean, I should say a fraud statute of limitations does not bar a breach of fiduciary duty.
Breach of fiduciary duty, but it's really a fraud. I mean, does a label that you put on it matter? I mean, if you're saying, and again, let me go back. I mean, you could have a trustee or an executor commit a breach of fiduciary duty, and there's no fraud involved. They did something that was inappropriate, and it's just a breach of fiduciary duty. And then you can have a fraud where it sounds more like fraud because it involves misrepresentations to the beneficiaries or the heirs. Does it matter that you label it as a breach of fiduciary? I mean, what you labeled it as a breach of fiduciary duty? Fine. But if it really comes down to the elements or the facts are a fraud, doesn't that then implicate the statute of limitations?
Well, I don't think it does, because we would have to, if we were here arguing that we had proven a fraud claim, the other side would be saying, wait a minute, there's 7 elements to fraud, and you didn't try and prove those at trial, and the judge never ruled on it. And that was the case here. We did not bring a fraud claim. We did not try and prove the 7 elements, or in the case of constructive fraud, maybe it's 5 or 6 elements. What we proved is a breach of fiduciary duty, which has only 1 element. And so that's why I think it does make a difference. That the statute, just on its face, refers to fraud, and fraud has a very well-recognized meaning under Arizona law, and it doesn't extend to just a breach of fiduciary duty claim. We are, as we mentioned in the briefing, the word fraud is not even mentioned in the court's extensive findings, and it was not tried to the court. What was tried was a straightforward breach of fiduciary duty case.
Can I ask you if Ms. Kimball had not retained any interest in the property, but clearly breached her duty and maybe received, let's say she received $500,000 and she just sold it immediately, would there be any claim against the LLC that purchased the property outright from Ms. Kimball?
The issue, there would be if the LLCs were not a bona fide purchaser for value. If they were a bona fide purchaser for value, that would have ended. That would end the matter.
The court found that they were a bona fide purchaser for value, did it not?
Court found that they were not bona fide purchasers for value in these circumstances. But that would be the issue. In fact, that's sort of. Let me turn now to these issues of time. The passage of time.
Find specifically as to every member of the LLC, it imputed the knowledge then, is what you're saying, from Ms. Kimball to the...
Yes. In fact, to be more clear, because this part is a little complicated, there are actually two LLCs, 7 Bar and Banjo. At the current time, Banjo owns about 252 acres or 250 acres of the property, or at least legal title is in the name of Banjo. As to Banjo, the court found that they were not a bona fide purchaser for value, and that issue has not been appealed. That is not before you. So at least as to the 250 roughly acres owned by Banjo, that issue's been waived. It's now turned to 7 Bar, who owns the remaining roughly 150 acres of the property. The court found 7 Bar was not a purchaser for value without notice for two reasons. Number one, the court found that there was no value exchanged. And what you heard from Mr. Cole was that, 7 Bar itself sort of gave itself as the value. And so therefore there was value. I mean, I've never seen a case where the entity which is supposed to give value claims that it was the value. It really doesn't make sense in any precedent that I know of. The fact is, in I forget, my mind's gone blank on the dates, but at one point in time when Patty Kimball and Mr. Tucker got together to talk about the Tuckers helping, they signed this handwritten 2-page document that has been referred to as the joint venture agreement. I think that was in 1998. And then, as the court found, there was a joint venture arrangement that they pursued, and it was not until 2 years later, in November of 2000, that the property was actually transferred to 7 Bar. And the court found there was no change of money, there was no exchange of value, nothing. So that's the first reason the court found that 7 Bar did not pay value. Secondly, the court found that Patty's knowledge was imputed to 7 Bar because they were joint venture partners. Certainly initially they were. And also because Patty was one of the agents of the property. She was managing the property. She had the power to write checks, and she did write almost all the checks for the property. She recorded plats on the property. The court found that she was acting as an agent for the joint venture even after the LLC was formed. So for those reasons, the court found there was no value paid, and the entity had notice imputed to it. And that's pretty straightforward Arizona law. If you get together and you're a joint venture, it's an entity. So for the entity to have knowledge, it has to be imputed from its owners, and that was the case here.
And your argument would be that the creation of the LLC, your argument, as I understand it, would be that the creation of the LLC by two parties who both have either actual knowledge or imputed knowledge doesn't wipe clean the slate. That knowledge doesn't suddenly disappear because it becomes an LLC.
Exactly.
Right?
That's exactly right. Sure. And the other part is the LLC statute itself says you're not an agent solely by reason of being a member, but that doesn't preclude the fact that you might become an agent if you take on the actual duties. But that's correct, Your Honor. Let's talk just for a minute about the passage of time. There's a couple cases I want to underscore because they're very important to this case. There was a lot of time that passed between the death of Mr. Perkins in 1991 and the initiation of this lawsuit in 2008, and that's all been briefed as to the reasons for that. But it's not too unlike the results in the Giovanni v. Rascorla case, which we've cited in the briefings. In that case, Mrs. Sorsby was the administrator of the estate of her deceased husband, a man named Beasley. And he died in 1923. She was appointed as the administrator of the estate and filed a petition for probate, but then basically did nothing with it. She was also appointed as the guardian of the estates of the then minor children of her husband. They weren't her children, it was from the first wife. And then more than 20 years go by in which she basically does nothing. But in those 20 years, the property, which in this case was a residence, the property was lost, quote unquote, to a tax lien sale. Property taxes weren't paid, tax liens were sold, and eventually the owner of the tax liens foreclosed the tax lien, and he received a treasurer's deed. Just like in this case, there was a foreclosure and there was a trustee's deed that went to the creditors. The other side in that case, eventually there was as it turned out, the man who foreclosed on the property tax liens was Mrs. Sorsby's then new husband. And he then got the deed and conveyed the property to her, and she sold it in a contract for sale. Before that was consummated, a lawsuit was brought by the children, who are no longer minors. They're all grown up now. But they've been doing nothing for 20 years. They brought a lawsuit saying, wait a minute, we have an interest in this. And of course the other side said, well, no, 20 years has gone by. That's all by the by. And the court, our Supreme Court, disagreed and said that in view of the fiduciary relation existing between the appellee and the children of her deceased husband, appellee may not be permitted to repudiate the trust created as long as said relation continues to exist. So she hadn't really functioned for 20 years, but that didn't mean the relationship had ceased. She could have resigned, but she didn't. There's a lot of similarities to our case. The other case is Restel v. Whitson, and again, we've briefed that. I won't take time on it except to underscore this one point. In that case, the property that the estate administrator acquired was a land patent. And the Supreme Court went out of its way to say a land patent is the highest evidence of title and is immune from collateral attack. But then went on to say, however, that doesn't mean that we can't impose a constructive trust on the property if the equities so require. And that's exactly what the court did in that case. So that was property the estate never even had, because the administrator had applied for this land patent after the deceased died. He applied for it in his own name, and the court said, you had a duty to apply for that patent not in your own name, but in the name of the estate, and you breached that duty. Let me now turn to just a couple of the other arguments they addressed. We've talked about the statute of limitations. We've talked briefly about latches, but they didn't really say much about latches other than to cite the passage of time. But the fact is that the court specifically found, examining all the factors, that latches wouldn't apply in this case for a lot of reasons. But most of those reasons relate to the fact that there was no repudiation of the trust or of the fiduciary duty that was made to the beneficiaries, the heirs. And the case law suggests that latches doesn't start to accrue until there's been some repudiation made known to the heirs. Because it's not their fault. Their understanding that this trust exists, or that this property is being managed by Patty on their behalf, and they're doing nothing because that's their understanding, and they're relying on the personal representative of the estate.
Can I shift to a different argument? That
Certainly.
Mr. Cole didn't specifically address, but that I find interesting, which is the notion of these earlier conveyances, first to the East Chino group and then later to the Russo group, and whether either both conveyance removed the property from the estate such that a constructive trust was an unavailable remedy.
Okay.
That has some superficial appeal to it, maybe more than superficial.
Well, from a legal vantage point, the property certainly was deeded out of the estate by the personal representative deed, and it was deeded from the estate to East Chino Corporation. Now, the court specifically found that that transaction was not intended to permanently deprive the estate of that property. That was in.
Is that a question of intent, or is that just by operation of law that the conveyance left the estate? That's where I see the rub.
Well, I think intent does matter, because here's why it matters, Your Honor. Unless the heirs, since this is a transfer of the estate property to a company in which the personal representative had a financial interest, the court could void that transaction unless the heirs approved of it with fair disclosure under the probate law, the statute that we've cited in the briefs. Well, the disclosure and the understanding of the heirs as to what was going on then becomes important. And the court found that what they understood was happening was this was just a straw transaction, a temporary removal to allow the property, to allow the heirs to try and do something to find a way to raise the funds to pay the creditors to save the property.
I remember that part of Judge Mackey's ruling. What I don't recall is whether he took the next step you're suggesting and said, and therefore the transaction or the conveyance is void. Did he?
No, he didn't. He didn't say that it was void, but what he said was the intent. Now let me back up one step from this, Your Honor. What both the Restel case and the Giovanni case suggest is that these transfers of legal title, while they may, on a surface level, make it look like, well, gee, now that it's transferred out, it's too late to save it. But in this case, the estate remains open, and this is a key fact, because as long as the estate remains open, property can be transferred out of the estate, and it can be transferred back into the estate. That's part of what a personal representative does. And so it's very common for a personal representative, for example, to go after property that was improperly removed and say, hey, that belongs back into the estate. So it would have been possible, while this estate was still open, which it still is open, for that property to be found to have properly been sent back to the estate. So that's why that's one reason this is different. But the other reason is simply this. Just as the land patent that the administrator in the Restel case had was beyond collateral attack. In a similar way, this was legal title of the highest order that you couldn't attack. But the Supreme Court said that doesn't matter because what we're doing is imposing an equitable constructive trust and saying, sorry, you can't hold it, you're going to have to give it up, even though you might have a good claim to a legal title. And I believe that's what's happening here. The estate, the 12 heirs, are entitled under the law to this property that descended from their dad. Nothing ever changed that. And they were innocent, as the court found, they were innocent of all of this stuff. They didn't know what Patty was doing. They didn't know about the LLCs. All they understood was that this property belonged to the estate. It was in Patty's name, and she was managing it for them. And not until 2008 did their understanding of that change, in which case this lawsuit was brought. And so as a matter of fairness and equity, and that's what a constructive trust is, an equitable instrument to allow the court to put things right. And in this case, the court did put things right, with the exception of, as we've argued, and I won't take time, I've got 39 seconds to theoretically reserve for rebuttal, but I won't, because he didn't really spend time talking about the cross appeal. But Patty Kimball, who breached her fiduciary duties, should not be allowed to retain an interest in this property. And right now she has, number one, a 1/12 heir's interest in the property, and she has, with her husband, a half interest in the property under the rulings of the court. It shouldn't be that way.
I'm sorry, I thought it was a 25% interest.
Well, I said with her husband.
Okay.
You're correct, Your Honor. You said it right and I said it wrong. So for those reasons, we would urge the court to not only affirm what the trial court did, but to reverse to the extent of allowing the heirs to have the full value of this property. Thank you.
Thank you. And rebuttal, Mr. Cole?
Yes, Your Honor. And Judge Kessler, in your questioning about the allegations in the case reminded me of the Shakespeare line, "A rose by any other name." I mean,
The thought crossed my mind.
yeah, it's a poetic kind of morning. I'll send some flowers perhaps afterwards. But
Please don't.
Oh no, it's okay. You spell my flower budget on Mother's Day. But seriously, I heard it at least 3 times that the heirs had an understanding that it would go back to the estate in some fashion. Where did that come from? It didn't come from the documents. They say no such thing. They say that the property is being deeded out of the estate. They say the bankruptcy court says good to sell, and then there's a trustee's deed. That they got that understanding from somewhere. Someone put something in their mind that is different than what the written documents say, and that is fraud. Someone had a secret intent and led other people to believe differently so they could do something in accordance with that secret intent. And the statute, of course, doesn't say you have to prove fraud. It says, in the relevant part to the LLC defendants, if fraud is used to avoid or circumvent the provisions or purposes of this title. So when Mr. Dangerfield says, well, property can go in and out of estates, that's part of the purpose of the probate codes, but it didn't here because the heirs had a misunderstanding about what was being done purportedly on their behalf. That's exactly what the statute says. So I think that they took their initial pleading that said fraud all through it, which we quote in our briefing, and removed it once this problem came out. But it's still a claim about a concealed intent and people being led astray. By the way, whatever intent that was, they got a 15 months delay and they gave up. And then it got foreclosed on. There was a trustee's deed, and that's that. And they may have had some intent, but what they actually did was not consistent with that.
Thank you. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.